as we all grapple to understand it when you're a kid, it's very hard to understand. It's something I teach my own kids, which is that, like, when somebody's lashing out, generally speaking, that person has been hurt as well. And it helps my kids at least make some sense of it. It's not the kind of, that's not the kind of nugget that was shared with me when I was a kid. I wish it was, but at least at this stage of the game, I can help my own kids with some of that. So.
Hi, besties. So Blake Lively and Ryan Reynolds are panicking and they want to have this draft of a transcript struck from the docket. They don't want to strike the letter that they wrote, Wayfair, in response to Miss Lively's assertions that, there's proof that Wayfair is running a smear campaign through this ongoing retaliation through their lawyer, Brian Friedman. We talked about this yesterday about how Blake, in her deposition, allegedly told Wayfair that the only smear campaign she was aware of now had to do with the countersuit that was filed against her by Wayfair, and that Wayfair's argument that a civil complaint filed in good faith does not qualify as employment retaliation. And instead of arguing the facts of that, they've filed this motion to strike because Blake doesn't want the transcript on the record. And listen, they filed the transcript under seal. So literally no one has seen a thing. But here's what they said. Lively moves to strike the defendant's letter attaching the entire uncertified rough draft transcript of Miss Lively's confidential July 31st, 2025 deposition testimony, and to deny the letter motion to seal as moot. In rushing to file on the public docket the entirety of the 292-page transcript on the day they received it with no plausible legal reason to do so, the Wayfair defendants and their counsel have proved Ms. Lively's point that the transcript was ostensibly filed in support of their argument that there is no legal basis to assert that Brian Friedman or his firm have participated in, fueled, and advanced a smear campaign against Ms. Lively such that their conduct has amounted to public relations work rather than that of an attorney. So Lively is suggesting that Brian Friedman is not defending his clients, but instead he's just a PR agent. Is that maybe what Blake's lawyers are doing? They claim that, in fact, this tactic perfectly demonstrates the counsel as PR agent role, because there is no conceivable legal purpose to file the whole transcript, particularly given that it was not reviewed, corrected, or finalized, and a mere pages of it were cited in their arguments. Now, they could have just filed the 2 pages, but they were citing a portion of her testimony. And just because it hasn't been finalized or corrected doesn't mean that her testimony will change. This deposition was more or less, I'm assuming, recorded video. And then there was more than likely a court reporter that took the notes of, reporting on what was said. So there's 2 separate ways that they can verify what she said. They said the letter and the attachment should be seen for what they are, a manufactured excuse to force the transcript into the public domain as fodder for the Wayfair dependents' media campaign. It is surely not lost on the Wayfair dependents that given the pending motion to seal, the burden is on Ms. Lively to file a letter motion explaining the particular reasons for seeking to keep any of this transcript under seal. It's not even that big of a deal. Honestly, all they have to do is ask the court to keep it under seal. And he has almost always, Judge Lyman, granted the party's request to keep it under seal. Numerous times this has been done. She's acting like this is like a huge feat. The Wayfair defendants and their counsels hope to make Ms. Lively defend the continued sealing of the transcript so they can advance a false narrative that Ms. Lively is afraid of her deposition testimony becoming public, which is entirely untrue and deeply harmful. I really don't know how they can prove what her motivations are. Like, they're trying to go into the future. So they're trying to say that they will be advancing a false narrative, that she's afraid of her deposition testimony becoming public, which is entirely untrue and deeply harmful. Okay. So if it's not true, then why should it be unsealed? Not sealed. Why should it be sealed? Miss Lively affirmatively pursued this litigation with the full intention and desire to have her testimony heard in the legal process governed by the rules of evidence, which publicly filing this rough draft transcript in this manner substantially undermines. To suggest otherwise is part of the ongoing character attack that Mr. Freeman has been advancing to undermine her credibility and taint the jury pool. This is not a proper use of confidential discovery material or the court's docket. Okay, so that document wasn't even filed by Brian Friedman. It was filed by Kevin Fritz. There's a note here at the very bottom. It says, even as the 2 pages cited, it makes no sense to just suggest that facts in Miss Lively's personal knowledge, as opposed to facts developed from public record from the investigations of others and through discovery, would be particularly relevant to never mind dispositive of the nature of Mr. Friedman's conduct in connection with his this action. Moreover, the Wayfarer defendants compromised the confidentiality of the proceedings by applying only a single narrow redaction to their letter while openly characterizing it in unredacted arguments, substantially disclosing their spin on the alleged substance of her testimony. Their spin. So again, they're trying to really hammer home that, Mr. Friedman's not an attorney, but they're trying to spin this. I think, they didn't even they had to respond because Blake filed into this court about the hearing, and she's trying to get them, the judge, to allow her access to Brian Friedman's records. And so right now, Blake is really trying hard to convince the judge that Brian is actually not an attorney, but rather working as a PR agent to get over the attorney-client privilege. Accordingly, Ms. Lively respectfully requests that the court strike the uncertified rough draft transcript from the record and order the defendants to file only the portion of the transcript cited in this letter, granting Ms. Lively's motion to strike counsel's inflammatory letter because the sole purpose of the letter was to promote scandal. I don't know about that. Consistent with their goal of creating a media circus. Oh my God. Every time they use this excuse, the freaking judge gets annoyed. Everything they file is not for legitimate legal purposes. Everything they file in response to what Blake does is not for legitimate purposes. It's only to create a spectacle. Only. Consistent with their goal of creating a media circus around her deposition, it appears the Wayfarer defendants immediately leaked details from the deposition to the tabloid media. This began by selectively sharing from a source in the room that Mr. Baldoni was in attendance, apparently to advance the storyline that the deposition was a face-to-face showdown between Mr. Baldoni and Miss Lively. The next day, more leaks from a source close to the deposition described in detail Miss Lively's attire for the deposition, also revealing those who accompanied her, mocked her legal team, and then discussed extensively the Wayfarer defendants' themes from their now dismissed case. The narrative created was that Miss Lively needed a large contingent of people with her to testify while misleadingly suggesting that only Mr. Baldoni and Mr. Friedman were present in the deposition on her side. The reality is that Miss Lively testified across the table from Mr. Baldoni, Jamie Heath, Steve Sarowitz, Melissa Nathan, and Jennifer Abel, all of whom attended this deposition in person, as well as 8 attorneys representing the Wayfarer and Wallace parties, 2 of whom questioned her. Well, they had a lot of documents that they had to go through. I'm sure they needed a bunch of lawyers to help them with all of the video and all of the, discovery that they had to bring over to Blake's attorney's office. From the inception of this litigation, Mr. Freeman has falsely accused Ms. Lively of being afraid to testify and delaying her deposition, and has made a spectacle of it in a number of ways, including ghoulishly suggesting that it take place in Madison Square Garden. That was a joke. To be clear, Ms. Lively's deposition transcript should remain confidential and under seal unless and until it becomes a subject of a legitimate filing, and then only if any presumption in favor of public access is overcome. By itself, the transcript is deposition discovery material, which, like other materials, merely exchanged among parties in discovery. And the law is clear that parties may not force material into the public view by manufacturing reasons to file it in the public docket. Literally, they had to file something because they keep trying to get Brian Friedman's documents. So it's like every time they do something, they have to claim that it's for a legitimate reason. And listen, Like, more often than not, deposition transcripts are not public, and I don't expect it to become unsealed, especially a rough draft, because they could finalize, they can edit, and then once the final draft is ready, then it's published. But I don't expect a judge to unseal this in any capacity. Filing the uncertified rough draft of the deposition transcripts when it serves no legitimate litigation purpose is disrespectful to all types of allegation at issue here and to the litigation process. It harms harassment retaliation victims like Miss Lively, who already bear physical and mental health consequences from the underlying incidents and are forced to repeatedly relive the trauma about through litigation. Did you see that? How they flipped that? This is more of a PR document than anything. They're trying to claim that Miss Lively is a victim of this retaliation campaign. And now so many people have filed the chilling impact of her trying to control speech. Listen to this. Who are already bear physical and mental health consequences of the underlying incidents are forced to repeatedly relive the trauma through litigation, including court filings, depositions, and testimony. And in this case, also through seated press and social media gossip and scrutiny about her confidential testimony, thanks to the Wayfarer defendants. Such tactics also have an untold chilling effect that serves to silence other sexual harassment victims. Do you see what she did there? She's trying to silence us as sexual harassment and sexual assault victims and domestic violence victims, but she's claiming that they're trying to silence her. It's all just spin. She requests the court grant her this motion to strike the uncertified rough draft deposition transcript and deny their letter motion to seal as moot. Now, what they're not doing is taking the letter away that Kevin Fritz filed on Friday, which was claiming that Mr. Friedman is not working as a, PR agent, and that their argument is that Blake Lively testified that there was no ongoing smear campaign. And yet here they are again through litigation claiming that there's an ongoing smear campaign when the facts are they have litigation privilege. This is not retaliatory. This is litigation, Blake. It clearly it boggles my mind that these people are so, they can't handle the truth coming out. And so anytime a little bit of truth comes out, they have a panic attack and they get it struck. And maybe he will strike the full thing. You know what I mean? Like maybe he will file, maybe he will strike the whole document and they will just refile 2 pages of the transcript, which is fine. They don't need to file the whole transcript on the docket. And even if they have to file a letter motion to reseal it, the judge isn't going to unseal it. There's already a rule in their protective order that these transcripts are not, they're confidential. So I don't know. It just seems like a lot of faux outrage. But I want to just touch on something that I got from an insider today. And I think it's going to help better explain to you guys why they keep saying that Brian Friedman is working in PR and not as an attorney, and why they are accusing Wayfair of filing everything as though it's going to be a PR spectacle, because it's not really what Wayfair is doing. But for Ryan, every single filing that is negative for his wife or himself ends up affecting his public image, and it is impacting the businesses tied to him. And Ryan's orchestrated a lot of this dispute, according to my insider, because of a planned IPO of a company that he was a part of called MNTN that had been in the works for years. And the IPO was supposed to coincide with Deadpool Wolverine and It Ends With Us and ride in off that success to help investors bring the stock public and make millions, like upwards of 90. And all of that came crashing down. This will also explain why Ryan's company, Van Zandt, filed a sham lawsuit in order to get Jen Abel's phone on September 27th, 2024, because on September 27th, 2024, Bloomberg announced that Ryan Reynolds' backed company, MNTN, was set to go public in 2025. On the same day an announcement about the IPO went live, Ryan filed a sham lawsuit. to try to find out who was damaging his reputation and get Jenny Abel's phone. It's not a coincidence, in my opinion. Part of what's happening here, so an insider from the banking industry, no less, wild, someone that used to work at one of the banks that underwrote the IPO of MNTN, which was the API digital marketing company that Ryan was involved in. And they went public, and their public offering was on May 22nd of this year. So just a couple months ago, they went public. Well, Ryan's company, Maximum Effort, was dumped by MNTN right before they went public. And for years, they had been preparing this IPO to go public and had been using Ryan Reynolds and his creative genius as a way to lure in investors, as like, look who we have all of these people behind us, and the creative force of MNTN is Ryan Reynolds. Okay. So they started drafting like their initial offerings, and they went through it for several years. But they started ramping up the discussions with the goal of going public in 2025. And it was in September of 2024 that they announced publicly that Ryan Reynolds MNTN would be going public. Okay. So when they announced the public offering and that they were in the process of having this company go into the public stock market, Ryan Reynolds was the face. That's how they were marketing it to investors. Ryan was in the middle of this planned IPO that they had been working on for 5 years. And part of what apparently my insider told me was that there was a coordinated effort between Ryan and MNTN and Blake and all of them that they were going to try to ride off the success of Blake and Ryan having this amazing summer with Deadpool coming out, and then It Ends With Us. And Blake was supposed to take over It Ends With Us so that they could show that they were a powerhouse and that their marketing efforts and their promotional efforts, Ryan's, were the key factors around the success of these films. And that was supposed to help, allegedly, the marketing IPO, the marketing company MNTN, where Ryan at the time was the creative force behind it. And he still is listed as the CFO. So when this was all being launched, they announced it in September, but then shortly thereafter, they started changing directions as the public backlash started going not in the favor of Blake and Ryan. And Blake and Ryan's marketing of It Ends With Us was then blamed on Wayfair. So my source says that Wayfair had nothing to do with the marketing because Sony was brought on for that purpose, that Maximum Effort led it, which you all saw, and that Ryan was desperate to protect the successful launch of the IPO because he stood to make like millions, like $90 million on this transaction, allegedly. And so he was working his butt off to, get this up to speed. And when his marketing campaign failed with Blake's launch of It Ends With Us, he was desperate to then allegedly pin it on someone else because a failure of this magnitude could impact the stock price and the future prospects of the company MMTN, because is the creative force behind MMTN's creative genius really all that genius if he has such a colossal marketing failure? So what happened is that in August, as they're preparing for the IPO to go public in September, he's desperately trying to get Wayfair to take the fall for this so that he can protect his investment, allegedly. And that's that letter that they sent on August 12th was like a letter from, Blake Lively and Ryan Reynolds about taking responsibility for the marketing. And they wanted Wayfair to take the fall for their marketing choices. Okay. That was apparently because he needed to protect the IPO launch. So allegedly. So in September, they announce it that they're going public with the IPO. And then in February, they do another draft for the IPO in November, then in February 3rd, and then their final is on February 28th, 2025. And in every single filing up until the very last one that was filed publicly, MNTN was using maximum effort and the acquisition of Ryan's marketing company as a benefit to investors. And then suddenly on February 28th, they announce they are departing and cutting ties with maximum effort, and maximum effort was going to be sold back to the affiliates of the original owners. This wasn't planned. It wasn't a planned divestiture by any means, according to my source, that this all was because of the lawsuit filed by Baldoni. But apparently, when Justin Baldoni filed the amended complaint and he shared the letter that Ryan Reynolds wanted them to put out, taking blame for the marketing, behind the scenes, I guess the people at the banks and the investors that were underwriting this and getting this forward realized that Ryan was trying to pit his failure onto someone else so that he could confuse investors and protect his investment. So, and my source thinks it was like a $90 million that he stood to make if it went public and he was still a part of it. So, around the time that they're getting ready to launch this February IPO, Blake and Ryan were seen on a lot of red carpets. They were at Saturday Night Live. He's seen out with at an event with Hugh Jackman. He's seen doing all these public events, and it was apparently designed so that they could look like they were rebranding, so that again they would look marketable to the investors when they went for the IPO. Then apparently there was concern that the lawsuit that was filed against him by Wayfarer would be a liability to his marketability and the future of MNTN. So that's really allegedly what the divestiture was about, allegedly. But the Time cover, where he was listed as like a powerhouse for Time magazine for top businesses, and Blake receiving the Titan Award, were supposedly paid for either through promises of advertising to Time magazine or something else, but they were supposed to go hand in hand with the IPO launching. So he gets the cover of Time around the same time that the IPO launches, but it was before, when he was still a part of MNTN, that was planned. And same with Blake getting the Titan Award. And all of this was apparently being done to help strengthen the investors on the powerhouse of who Blake and Ryan are. And when they were at the Time magazine event, the Time 100, and Ryan said to Blake, you could see him whispering to her, like, I need this more than you do, in terms of like getting her to say the right things. And then her speech was all weird and convoluted. Well, again, that was all to help strengthen and restore her public image, allegedly to help the IPO. So what ultimately ended up happening was, while Ryan owns shares in the MNTN, he's no longer considered like a part of the company, and he didn't make the kind of money when the IPO went public because of everything that happened here. They had spent 5 years working on this going public, only to have all of this fall apart at the end because he failed on a marketing gig, and he was desperate to cover up his failure and pin it on someone else so that IPO could go through and that he could make all of this money, allegedly. That's the allegation that this insider is suggesting is a factor here. If that's the full motive, I don't know, but they just said that Ryan stood to lose a ton of money and ultimately did lose money because he didn't make the kind of money he would have had his company still been a part of MNTN when it went public. But they were absolutely positive that the Time magazines, his cover and Blake getting Time 100, was a coordinated effort so that they could help the IPO. They also claimed and alleged that Blake taking over this It Ends With Us was also supposed to be so that Blake could look like a powerhouse with Ryan. They would have all this momentum of what a powerful couple they are going into the announcement of the IPO going public. And then that just all came crashing down. Now, they made money with their initial offering, and the stock itself has been kind of volatile, and it's a risky stock nonetheless. but they didn't make as much money as they could have. And some investors apparently were left very upset when it was all said and done. And Ryan lost money. And MNTN, I don't know. The history of MMTN is kind of sketchy. They're not the most reputable company. They've been involved in numerous lawsuits for intellectual theft, intellectual property. They got sued the day after they went public for intellectual theft and stealing the software and the patent of someone else to develop their products, their development of their marketing system that they promote. And it's a mess. They were sued in 2016 for fake engagement. MNTN actually tracks IP addresses of people, and anytime one of their ads appears, they grab the IP address of the ad that clicks on the ad, and then they track that person's IP address until they get to the website, and then they claim that the ad is what got converted and got that person a sale, even if it's not true. And this person told me that because MNTN deals with engagement, fake engagement, AI bots, and using fake accounts to add more clicks to an ad to drive up the cost and to drive up what they take home, allegedly, that all of this discussion of fake engagement is because this is the kind of stuff that MNTN has been accused of doing and is involved in this whole world. Now, the settlements of these lawsuits occurred and they denied all wrongdoing, but it was a whole thing in 2016, and they had to rebrand, and they brought on Maximum Effort to save the company in 2021. And then right before they go public, they dump Maximum Effort because of all of this. So the reason he might have wanted our IP addresses is to track us for the content creators. He also would have been able to, if he got our addresses, our back login information with these subpoenas. So he subpoenaed our IP addresses, our names, our addresses, our phone numbers, our email addresses, and our backup email addresses. They suggested that it could have just been done for the purpose of hacking, but also to use our IPs for fake engagement and also to clone us and to do covert cloning of our identities to effectively ruin our reputations. That was they said there's a lot that can be done in AI, and it's scary. And so for those people that fought the motion to quash, you should be happy, because the last thing any of us need right now is Ryan Reynolds possibly, cloning our identities and trying to hack into us and destroy our businesses, because also Ryan doesn't want bad videos of him on YouTube, because MNTN relies on ads generated that play on YouTube videos. So they don't want their chief creative officer apparently getting bad press. So with MNTN's history of allegations of fraud and stream scam and click ad fraud and fake engagement and spoofing of other people's IP addresses, it's scary that Ryan, who's the chief creative officer of MNTN, also trying to keep and continue this, IPO that's now very public, marketable, but now going after our IP addresses, knowing the history of them, is kind of scary to me. And it's an allegation, but it also explains why, in my opinion, he keeps going after Brian Friedman and saying, all you're doing this is for PR. Everything you're filing is for PR. All you're trying to do is hurt our reputation. You're not actually a lawyer, because Blake and Ryan are tied together, and Ryan is still part of this deal, even though they're public now. He's still being touted as their chief creative officer, and a lot of their success now public really relies on him. And so the more and more and more he is tarnished, the less successful this company can be, and that can impact investors. So who really had the motive here when the IPO is announced the same day that the Van Zandt lawsuit is filed, and it's through Ryan's company? Who's really behind the lawsuit? Who is alleged to have lost somewhere of $90 million in this? And who keeps fighting this, even though Blake apparently, is kind of over it, as evidenced by her deposition? And is all of this just a cover up for Ryan to protect an investment and to mislead investors? I mean, that could be securities fraud, but they didn't mention any of that in their IP filings. So listen, they've been very careful. Let me know what your thoughts are, though. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and click the bell so you never miss a video. Thanks so much for watching. Bye, besties.